The lesson to be derived from today's little presentation of argument in this case is that there is strength in numbers. Here's what we're talking about today. We are again in the continuing case of the San Antonio police officers. Melissa Perez was having a schizophrenic episode. These police officers were called because she had cut some wires in a fire alarm system. There is an issue in the case as to whether they were burglarizing her house by entering it, whether they had a valid reason to go in. When they tried to go in, she attacked them with a hammer and they shot her and killed her. And these three officers are on trial for murder. So that's where we stand at this point. Yesterday, they conducted an argument in the middle of the day about the admissibility of certain evidence. And there are some interesting evidentiary points in this case, too. And I hate to just do nothing but evidence, but the underlying case is pretty clear. And for the most part, what the state has been doing has been running body cam videos all day long, and the defense has been asking some pertinent questions along the way. But I don't think either side is necessarily gaining ground against the other. That's just my personal opinion. The jury may have a different opinion, obviously. So today, the issue is, before we get started, Judge, let's see about getting some of these exhibits admitted. And again, and this just blows my mind, they do this in front of the jury. The jury is looking at them going, why are you wanting to hide this stuff, prosecution? And that's, I think, a very interesting part of this. But the more important part is the argument. And I'm going to show you how that is.
We previously tendered to the state photographs to the 76 through, I believe it's going to be 90, whoops, 96. And they've agreed that they're admissible and they will be admitted. However, we need to introduce on drop the body camera, which is Defense Exhibit 98.
Which body camera? I'm sorry.
Andrade's body camera, which is Defendant's Exhibit 98, and Alfaro's, which is Defendant's Exhibit 99. And they have objected to a search warrant, which was signed at around 3:23 or so by a magistrate judge. I understand the state's going to claim that it's hearsay. However, we believe that the court can take judicial notice of it under 201 and 202. It's a court record, and it was signed in connection with the search of the residence that this CSI was collecting evidence.
This is an evidentiary trick that has resulted in cases being overturned on appeal, because there is a big difference between the judge taking judicial notice of something, for example, that there was an affidavit and there was a search warrant issued, and the affidavit and search warrant being relevant in the case. Now, they're going to make some claims about relevance, but relevance doesn't get you past hearsay, as we'll hear in just a moment.
And so we would ask that it be admitted. Also, we have photographs 98 through 103 that the state's going to object to. However, we believe we can cross-examine the witness on these. So I just wanted to clarify that before we began. And we're going to connect up 98 through 103, and I believe that the rules of evidence permit us to introduce evidence if we connect it up through other witnesses, and it would obviously be embarrassing to the defense if it would be stricken because we couldn't connect it up, but we believe that we can connect it up through Kinsey, who the state has subpoenaed, and the court has previously said that we can rely upon the state's subpoenas.
All right. State.
You're all right. The pictures he showed me, which was still shots of body-worn cameras, that we do not object to those freeze frames of body-worn cameras that have been admitted into evidence. He mentioned there were photos from 2 body-worn cameras that had not yet been admitted. If they admit those first, those body-worn cameras, I won't have any problem admitting freeze frames from them.
So those photos are Defendants Exhibit 76 through 96?
Yes,
Okay, so then I'll admit those.
and the body cameras that haven't previously been introduced are Andrade's Defendants Exhibit 98 and Alfaro's Defendants Exhibit 99.
I'll object to those.
All right, so 98 and 99 are admitted.
And I have a copy of Defendants 97, of course, we'll just look at it.
And that's a search warrant?
Yes,
The state's position that it is hearsay, and taking judicial notice is not just a free-for-all exemption to all hearsay.
I believe I just said that, but he's right. And the reason it's hearsay, even though it's part of a court document that has been used actually in this trial, the reason it's hearsay is because there's an affidavit attached to it. In order to get a search warrant, you have to swear out an affidavit. Hi, I'm Jim Jones. I'm the police officer who witnessed the following events or reviewed the following records, and here's what I found, and I swear to this on a stack of Bibles, all of that in order to get the warrant. And this isn't brought before a circuit judge like Judge Rangel here. It is brought in front of a magistrate, which is a lower level judge, and for the most part, magistrate judges are like rubber stamps on search warrants. It's, boom, I'll sign it. The utility of having the search warrant admitted and the affidavit admitted would be to, for example, question the person who did the affidavit. But the person who did the affidavit wasn't subpoenaed by the state, and the defense didn't subpoena him either. So there's no way to validate or authenticate the information that's in the affidavit, and the state has a very good argument here, and it should be sustained.
the state has proffered the theory that somehow or other officers have been trespassing or burglarizing a residence. And so, since there's a warrant, the collection of evidence, the removal of evidence is important in this case and gives context to why the evidence was collected.
Great argument on relevance, counsel, but you didn't address the hearsay issue. But in arguing to try to get this in, we find out obliquely why it is he wants to get this document admitted. It has nothing to do with the affidavit.
And they never got a search warrant until a year and a half later, collected under the theory that it was a murder.
Okay, so this one is Defendants 97. Are there others that you're seeking to introduce?
Yes, we want to introduce 98 through 103, which are photographs taken by Kenji Uno. We believe that we can connect that up.
98 and 99 are already admitted, right? Those are the body-worn cameras?
Oh, I'm sorry. I must have. I apologize for not marking them correctly.
So to be fair again, it's not just the prosecution that looks unprepared at times. Some of the delay in this is coming from both sides.
I will rectify that.
So you're starting at 100, Defendants 100 through...
Probably 105.
And
or 8. Let me see. Yeah, so you're moving to Defendants Exhibit 100 through 105.
Correct.
And just from Mr. Splinter's argument, he's purporting to offer to this witness. He's purporting to offer to this witness photographs that she did not take, that were perhaps taken on one day in other places by other people. And it's improper to ask this witness questions about pictures that she can't authenticate because she wasn't the one that took them. She didn't take them on the day that these pictures were taken. We have a right to cross-examine the witness that took the pictures and the circumstances in which those images were taken.
Now, that's certainly a valid objection because she didn't take the photos. Normally, in order to get a photograph admitted, the first thing you have to say is, you took this photograph? Yes, it's a fair and accurate representation of what you saw that day. Then the person will say yes, and boom, it's admitted. Of course, it has to be relevant, but if it's relevant, it gets admitted. So the solution for the defense at this point could very easily be, okay, Judge, we will have this witness subject to recall after we produce the other witness who can authenticate that. And in fact, in Missouri, that's pretty much what we do. But in Texas, they have a rule that actually covers this. And it's a pretty interesting rule, and I think it's a good one because it keeps trials moving. Not that this trial has ever really been moving. So the prosecution has the grand idea of, hey, the witness is sitting right there. Why don't we ask her if she's seen these? And of course, that's what they do.
I can't tell from this picture of where this is at in the apartment, but I did see similar.
100.
Yes,
Okay.
but I don't know where in the apartment that is. And I've never seen these items, no.
Judge, even though she may not have seen them, and maybe she can't authenticate them, if you'll give me a moment, I can tell you the rule of evidence that permits their introduction. I believe it's going to be Rule of Evidence 103 that you can admit evidence for limited purpose, subject to being connected up. And also, yes, on 103.
Yes, Your Honor, and just to add to that, authentication is the thing what it purports to be, right? That's all it is under 901. Right? Is the thing we're talking about what it purports to be. We got these in discovery from the state, so they agree and admit that they are what they purport to be, which is the pictures and the photographs taken by Kenji Uno at or around the time of in the apartment. The reason it's important with this witness is that we have the authentication. I mean, if we were bringing something that they did not believe was true, then I could understand that. But they know it's true. They gave it to us. But what's important about it is that, and it's not saying anything necessarily about this CSI, but there are things that are important to the investigation, the other investigation that started this whole thing, that she was not directed to take pictures of. So the jury needs to know what those photographs are that she did not take pictures of because she was not directed by the investigation. And as Mr. Cifuentes said, the witness that they know will easily come in and authenticate and say that it is what it purports to be will come in. And so we're asking that they be conditionally admitted, as Mr. Cifuentes argued.
So, how would the jury know that they're true, right? How would the jury know that they purport to show whatever it is they're supposed to show? If this witness cannot authenticate.
Because we all agree that they are, and so what we're doing is we're representing to the court that they are true. We've got them from the state who also agrees that they are true, and they are the photographs that they gave us. And the jury may not necessarily know now, but that's where the conditional part of it comes in. And so conditionally, we can talk about the fact that these are other items that were photographed in her apartment at or around the time of the event. You did not photograph these things. You were not told to photograph these things. These things can have relevance to the other investigation of the photographs you did take of the wires being cut at the fire alarm. Because that's what they are. It's batteries and things that she had stolen from the fire alarm, which this witness did take photographs of. And so it's really just showing that there was a missing piece in the investigation and not on her, because as she said, she relies on a detective to tell her that these are relevant and important. The fact that a detective did not tell her that they're relevant and important is relevant and important to our case. And so as far as the jury is concerned, I think where the conditional issue comes in is if we weren't able to have Kenji Uno say, I took these pictures at this time, which the state knows we're going to be able to do that, then the court would say, look, you just disregard those photographs, and that would be that. But if we didn't all know that this is going to happen later, And just for the purposes of not bringing her back and saying, all right, now let's bring you back and talk about you didn't take any of these photographs. That's all we're asking to do.
And I represent to the court that as part of discovery, Detective Soto wore a body camera where he interviewed Kenji Uno and he referenced these photographs. And there's an email that the state provided us in discovery from Kenji Uno to Detective Soto where he attaches these photographs as the photographs that he referenced in his prior interview. So there should be no doubt that these are true and correct copies.
Your Honor, and if I could just add one more thing. The state has gone out of their way to say there were no exigent circumstances in this case. Besides hot pursuit, another exigency would be because she escaped and there was evidence of the thefts that she had committed, which she admitted to on body-worn cameras that she had committed multiple thefts and burglaries of the fire alarm systems. The fact that these batteries were in her apartment, proof of those things. This witness was not instructed to look for evidence of that. The state provided us with those pictures. They know what that is evidence of, that it was evidence of thefts that were inside of stolen batteries that were inside of her apartment, which would constitute another reason for an additional exigency and not a burglary of a habitation by all of these police officers. So for that reason, it's very vital, and we can connect it up. Mr. Uno was on their witness list. They were the ones that provided us with these photos and this evidence.
In the mid 70s, up into the 80s, you used to find on television these shows that purported to be professional wrestling, or if you're from the South, professional wrestling. And they still call it wrestling down here. There's no A in that word at all, but it's just one of those regional pronunciations. I'm not really making fun of them. I'm just pointing out. I mean, they make fun of the way I say "worse," so I guess I can take care of making fun of the way they say wrestling. But you remember in some of those, you'd see tag team matches where one of the guys was getting the living's daylight stomped out of him by the other guy, and the guy who was supposed to come in only if he was tagged would jump off the rails, come over, bash the guy over the top of the head with a chair or something, and then he'd go back as if he'd done nothing. And of course, that guy stumbled around, holding his head, and it was very clearly 2-on-1. And of course, the other guy over on the other ring, he was like, he isn't going to have any of this. No thanks. He doesn't want to get bashed in the head with a chair. I just think it's funny because it reminds me of professional wrestling. And I know that's a bad look on my profession, but it really does remind me of that because there's 3 lawyers for the defense and they all have something to say, and it all goes against what the prosecution is trying to do. Now let's see how this actually wraps up.
This is the exact situation that this rule is designed for.
Have you talked to this witness? Have you lined him up?
That's your intention.
Well, this witness.
Hold on.
Okay, it's a fair question.
Yeah. But let me just do this. I mean, I understand the technicalities of everything. I am going to sustain the state's objection to Exhibit 97.
I hate to say I told you so, but I told you so on 97.
Which is the affidavit for the search warrant. I will allow and admit defendant's exhibits 100 through 105, the photograph.
Your Honor, may we admit that the warrant was signed on June 23rd, 2023 at 3:17 a.m. on page 2. If you're not going to admit the affidavit, can you redact the affidavit?
You basically just on page 2 that those were warrants signed at that time on that day?
Well,
So you'll make the affidavit, the second page of the affidavit, 97A?
yes.
Okay, so you're moving to introduce 97A.
Yes.
Response to that?
Just the warrant, is that what he proposed?
Yes.
Not the affidavit, which contains the hearsay.
Page 3 of 4 is the search warrant.
Can you just rip it off and label it just as one exhibit?
Yes,
Just a single numbered exhibit?
yes, 97A.
Yes.
Because frankly, the contents, the issue that the court had in sustaining that was the state's objection to hearsay on the affidavit portion. That the court didn't necessarily see an issue with.
So, why is the date of the affidavit so important? Because it wasn't strike that. Why is the date of the search warrant so important? Because the search warrant wasn't executed until a year after the actual shooting, the actual crimes that supposedly were committed. And as a result, this is one way in which the defense can attack the integrity of the investigation and the completeness of the investigation. It was, in effect, a rush to judgment, except it really wasn't. It was a reaction to public pressure. And that's, I think, what they're probably going to argue in closing argument. Look, they went a year before they got a search warrant on this particular episode. And as a result of that, you can tell that this case was put together on a shoestring, blindfolded, because these guys just wanted to make sure to go after 3 police officers or whatever argument the defense is going to make. I'm sure that it will be impassioned, and I'm sure that it will certainly resound in some ways, perhaps, with the jury. You have to remember that I believe, I'm pretty sure here, that they are not going for an acquittal. And the reason I say that is because the prosecution has been showing this video nonstop of the actual event. And so the jury has seen a lot of that. They've got to be tired of seeing that at this point, but they've seen a lot of that. And so it is unlikely that you're not going to have at least one person who feels sorry for poor Melissa Perez. Heck, I feel sorry for poor Melissa Perez. I just happen to think there's a different way of looking at the facts and that the defense has characterized them in a way that is going to give the prosecution some trouble. Now, whether or not the jury buys into that view or whether they come back with the view of the prosecution that this should never have happened, whatever they decide will be the right answer. But again, I think it's important in the context of this case that the jury know how this investigation was done at the beginning and how it was concluded at the end. And that's what the defense is going for here. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better, that would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.